Judge O'Donnell oversees the sentencing of Mr. Kreider, who has been convicted of abusing his biological daughter.
For today, those reports have been completed and the state's prepared to proceed with sentencing.
You are required to register in person with the sheriff of the county in which you establish residency within 3 days of coming into that county, or if temporary domiciled for more than 3 days. To register, failure to verify residence at specified times, or failure to provide notice of change in residence address or other required information as described above will result in a criminal prosecution. All right, Mr. Mastandrea, go ahead.
Thank you very much, Your Honor. Rod Mastandrea on behalf of Mr. Kreider. Your Honor, there's not much to say here other than I do want to say that my client is profoundly sorry for all of the actions and transgressions that have happened here. I'd like the court to know that all of the sentiments that are going to be echoed here in the sentencing memorandum, my client certainly is going to spend the rest of his life trying to atone for this. Whether or not he ever will be able to do that, I don't know, but I know that he certainly is very, very sorry. To that end, Your Honor, we would just like you to consider running any sentence that this court may impose concurrently, and we would ask that the court consider everything in the sentencing memorandum about my client. He's already 61 years old. He would like an opportunity in the twilight of his life, for any amount of time that is, to be around people that love him or around his family and continue to make those amends as much as he can. He understands that that's probably going to be a very, very far-fetched idea, but certainly my client cannot be more and more profoundly sorry. Thank you.
Thank you. Mr. Kreider, what do you want to tell me before I impose sentence?
I'm sorry for everything. Sorry for everything.
Anything further you'd like to say?
Sorry to everybody that's involved.
Saleshi?
Thank you, Your Honor. Prior to addressing the court, the victim's mother would like to speak.
All right, would you just state your name and tell me whatever you want me to know?
Valerie Russ.
Okay.
Am I allowed to read it?
Yeah.
I can't believe we are here. I don't wish this on anyone. It's very hard as a parent to watch your child go through something like this. I hope you run. I sit on the aisle. You don't get that pleasure anymore. You make me sick to my stomach. So I hope you rot and karma gets you for everything that you did to her.
Thank you. Saleshi?
Thank you, Your Honor. In this case, it's difficult to imagine how this could be much worse. The defendant was the victim's biological father, someone who should love, protect, and care for the victim at all costs. And the victim was, and still is, just a child. She was someone who was vulnerable, dependent, and trusting of the defendant. And instead of being the parent, the man that he should have been, he abused her. And this went on for years.
That's bull.
Hey, stop. Sorry.
He would put...
You will have a chance. I'll give you another chance to talk, but right now, she's up. Got it? Go ahead.
This went on for over 5 years. The harm in this case extends beyond just physical. We don't need a psychiatrist or a psychologist to come in here and say that the victim will endure lifelong emotional trauma as a result of this. She already is in therapy. Her childhood, her sense of security, and her trust in the most fundamental human relationship in her life were taken from her. And the victim in this case was not just young, and she was profoundly innocent. One thing that stood out to me when I was evaluating this case was when I reviewed the victim's cell phone extraction, which had a search history that was asking if Santa was real. I think that single search is a glimpse, a heartbreaking window into just exactly how old and how innocent she was at the time that this happened. She was a little girl trying to understand the world, seeking answers about Santa Claus, and that stark contrast could not be more disturbing. I recognize that the defendant took some accountability by pleading and avoiding having to put the victim through a trial in this case, but he still continues to minimize his conduct. In the pre-sentence report, he stated he did not put his blank in her, and given his response here in court, he said, "That's bull," when I mentioned what exactly happened. When asked what he did do, he said he played with her, he guesses. And when asked how long this went on, he said a little while. There's no sentence that this court could impose that can undo the damage the defendant has caused here. But this court can ensure a punishment that reflects the seriousness of the defendant's conduct and protects the community from an offender who betrayed every conceivable duty as a parent and a human being. The charges the defendant pled to in this case do not merge. The state is asking for a maximum consecutive sentence. I understand, I recognize, and I appreciate that this will be virtually a life sentence for the defendant. But I think anything less would be a life sentence for the victim. She deserves to graduate high school, to go to college or start a career, to start a family if that's something she wants, without having to worry about where the defendant is or what he's doing. A maximum aggregate sentence here would not be disproportionate to the defendant's conduct, and we would ask that the state impose such sentence. Thank you.
Thank you, Mr. Kreider. You indicated when Ms. Alessi started talking, when she was talking about the activity, you said that's bull. So now's your opportunity to say whatever it is you want to say in response to that.
No.
What?
No.
No? Okay. Well, it's my recollection that you pled guilty with the activity outlined by Ms. Alessi. Now you're telling me that you didn't, by your statement, that's bull. It kind of indicates that you didn't do those things.
I didn't do some of that.
What?
I didn't do.
When you were presented with the paperwork to provide your written version of what occurred, you did not return that. You indicated to the corrections staff that you could not read or write and could not fill out the pre-sentence questionnaire. Is that true?
Yes.
It is. You're aware that your phone, the information on your phone was extracted, correct?
Mm-hmm.
Right. Pretty proficient on the use of texts. Is that right?
Yes and no.
Yes and no. Well, I
speak it, and it puts,
Okay. So you use that voice activation?
Yeah.
Okay. And so when the victim says on 2/27/25, I can't come this weekend, I can't call, you then speak into the phone, why not? Right?
Yeah.
No, you didn't? Well,
Yeah.
somebody's got your phone then, or what?
Yeah. I said yeah.
Okay. And then the victim says, I'm on the bus. And your response by voice activation, why can't you come this weekend, right?
Mm-hmm.
And then, immediately after that, and don't tell me you're going over a friend's house because that ain't gonna fly. That was your response, right?
I don't remember, but
Well, I'm reading it.
Yeah.
This is
No, that's
information provided to you and your attorney by the state from your phone extraction. So you responded that way. Then she says, I have to help my grandma clean and do other stuff. And you say, whatever. Victim, I do not know why you are getting mad. Question mark. Because it happens all the time. Victim, I'm going to bed because I have a headache and I'm very tired. Good night. Your response? Good night. So you seem to be able to read exactly what she's texting to you before you respond, because all your responses are appropriate for the nature of the conversation. Isn't that correct?
yes.
Okay. So you can read.
No, I can't.
You can't.
It reads it to me.
Okay. All right. How is it that you're able to navigate the internet and go to some of those most vile websites with links that you clicked on?
I have no idea what you're talking about.
You have no idea what I'm talking about. Well, yes, you do. Okay.
Actually, I don't.
All right. Yeah. Well, I'll give you an example. On 2/28/22 at 5:47 and 21 seconds, you click on a link. There are countless websites, countless links that you clicked on and went to. Did you not?
I might have.
You might have. It's something
Probably
that
did.
what escapes your memory?
I probably did.
You definitely did.
Yeah.
Okay. So you're going halfway there. You're going halfway here with everything. Okay. As Ms. Alessi indicated in your pre-sentence report, you indicate that you didn't do the things she said you did, right? That's what you told the PO, right? Right?
Yes.
Okay. That you just played with her a little bit. What does that mean exactly? What does that, tell me what that means. Quit your crying and tell me what that means.
Messed around with her.
Okay. Tell me what that means. You tell me what specific activity you engaged in with that 8, 9, 10, 11, 12, and 13 and 14-year-old girl. Tell me.
Stuff I shouldn't have done.
What? What did you do?
Touched her.
Touched her how?
Inappropriate.
Okay. See, you won't say. Okay? You won't say what you did. You won't admit to yourself what you did.
It shouldn't have happened.
Of course it shouldn't have happened. It's your daughter, for God's sake. Of course it shouldn't have happened. Now you come here, you profess to take accountability and responsibility for what you've done, and you don't take one bit of responsibility for what you did because you can't even admit what you did.
Sorry.
You're sorry. Empty words, because you're not sorry. If you were sorry, you would admit what you did, but you won't do it. Just like you might have gone on these websites, right?
I did go on the website.
Right. Finally, an admission to something. You had a suspicion. You're perceptive enough to have had the suspicion that when she was calling you toward the end of this nonsense, that she was on speakerphone and other people were listening. And you begged her over and over not to tell anybody, right? Isn't that right?
Yeah.
Why did you beg her not to tell anybody?
Because I was going to get in trouble.
You were going to get in trouble. Okay. So that your primary concern was for you
No.
not to get in trouble. Right?
Yes, and I wanted her to talk to her to work it out.
To work what odds?
To so I don't mess with her anymore.
Why didn't you just stop doing it? What did you need to work out with her such that you would stop messing with her anymore? Why didn't you just do it?
That's what I was going to do.
You were gonna do.
That's what I was going
Okay,
to talk to
I
her
don't
about.
want to hear the answer to what you were gonna do. Why didn't you stop?
I was going to.
You were going. When were you going to?
When I talked to her.
Great. That's a great plan after 6 years of this shit. Miss Alessi was 100% correct when she said that she couldn't imagine there's anything more vile than what you did. I can't imagine what goes through somebody's mind that does that. Now, you came here when you had a chance to talk and said through your crocodile tears that you're sorry. Okay? Now, when you were talking to the probation officer and compiling this report, not one time did you express anything that indicated you gave a damn about the situation that your daughter was in. Your daughter was in during these 6 years and will be in for the remainder of her life. All you care about, okay, all you professed to the probation officer to care about was getting out in 10 years. You know why that is? Because you're a selfish person. You were a selfish person with your daughter, and you remain selfish to this day.
Not so.
You are very selfish. You're the definition of selfish. All you give a damn about is you.
Not true.
Not true. Very true.
I love her.
Yeah. That's ridiculous, okay? That's an offensive statement that you love her, okay? After you did what you did to her for all those years. So don't give me that crap. Anything else you want to say? All right, I've reviewed the pre-sentence report. Reviewed the victim impact statement. I've listened to Ms. Rux. You can remain seated.
All right. Sorry, Judge.
It's all right. I have reviewed and considered all the information in the sentencing memorandum, considered what the defendant has said, what Mr. Mastandria has said, what Ms. Alessi has said. And I have considered all the provisions of 292911, 292912, 292913, and 292914. On count 13, I'm going to impose a prison sentence of 60 months. On count 14, I'm going to impose a prison sentence of 60 months. On count 6, I'm going to impose a prison sentence of 10 years up to life. On count 7, I'm going to impose a sentence of 10 years up to life. And these sentences will be consecutive to one another. And that's because consecutive service is necessary to protect the public from future crime by you and for the appropriate punishment. And they are not disproportionate to your activity that you engaged in, to that seriousness, and to the danger you pose to the public. Now, there were you pled guilty to 4 offenses, 4 separate offenses. So they were committed as part of one or more course of conduct that went on for upwards of 6 years. And the harm caused by you to your daughter by at least 2 of these offenses committed were so great or unusual that no single prison term for any of the offenses committed as part of that course of conduct adequately reflects the seriousness of your conduct. So, and I have just because it seems to be a specific issue, consider the overall length of this sentence. Now, when you get out, you will be on post-release control for 5 years under the parole authority with conditions. If you do not follow their conditions, they could return you to prison as part of this sentence for 9 months for each violation, up to 1/2 of my sentence. If that violation is a new felony, then you could get an additional consecutive prison sentence for the violation, the maximum of which would be the greater of 12 months or the time left under your post-release control. Now, since I gave you a maximum consecutive sentence, you have a right to appeal that sentence to the 11th District Court of Appeals. You have the right to have a lawyer represent you in the appeal. If you can't afford one, one will be provided free of cost to you. You have a right to have a transcript of the hearings. If you can't afford them, then they'll be given to you free of charge, and you have a right to have a timely notice of appeal filed on your behalf. The costs are assessed and the remaining charges are dismissed. Is there anything else, Ms. Alessi?
No, Your Honor, thank you.
Ms. Andrea?
Your Honor, at this time, I do believe that my client is going to be indigent and would request that you appoint somebody for that appeal.
All right, I will appoint the Lake County Public Defender for the appeal.
Thank you.
During the hearing, the defense attorney asks for leniency and describes the defendant as remorseful. While Mr. Kreider offers a brief apology, the victim's mother delivers a powerful statement describing the deep suffering her child endured. The prosecution pushes for the harshest possible sentence, pointing to the defendant's betrayal of trust and his ongoing attempts to minimize his actions. Judge O'Donnell directly challenges Mr. Kreider, using phone records and text messages to expose contradictions in his statements and questioning the sincerity of his remorse. Ultimately, the judge orders consecutive sentences, including 2 counts of 10 years to life, emphasizing the seriousness of the crimes, the lasting harm to the victim, and the need to protect the public.